my name is Tsecho Khailai. Welcome back to my Lawyer's Corner, my very, very untidy Lawyer's Corner, which I need to make time to pack up. But welcome back to my Lawyer's Corner. My name is Tsecho, and if you are new to my Lawyer's Corner, I really want to give you a very warm welcome. If you are a returnee to my Lawyer's Corner, I'm so glad to have you back. I'm glad that we continue to learn together, to grow together. Now, for those of you that don't know, on my Lawyer's Corner, we share insights and nuggets into South African law. A disclaimer is that any information shared on my Lawyer's Corner is not to be construed as formal legal advice for your own personal matters. If you have a personal matter that you require legal advice for, I do suggest and encourage that you see an attorney, book a consultation so that they can look in depth into your merits and advise you accordingly. Now, it's the very early days of January 2024. It's the new year. And yes, Happy New Year to everyone. Happy New Year. And may everything that you want to achieve in 2024 come to light, come to life. And may you have the strength and the courage to chase your dreams and not to sleep on yourself. So yeah, without any further ado, I thought it would be important to talk about something that is probably happening to some, has happened to some are doing it, some want to do it, and that's the topic of absconding. So it's the very early stages of the year. The work year is about to begin for some. For some of us, the work year has already begun, and some employees will choose not to return to work for whatever reason. Your helper chooses not to come back to their employment, or you yourself are an employee and you decide to give yourself an extended break. What are the consequences and what can your employer do about those situations? So stay tuned. This is what we're going to be talking about today. So let's paint a picture, all right? You are an employee of a domestic worker, for example, and it's the early days of January and your employee is supposed to be returning back to work from leave or from a break that you gave them, and your employee doesn't return to work. The day comes when your employee is supposed to return back and they don't come back, and you call them and your phone calls go straight to voicemail, or they don't connect at all, or like you cannot reach them, you can't find them, you have no idea if they are coming back or not coming back. A day passes, another day passes, the week passes, 2 weeks pass, and your employee doesn't return to work. Do you then fire them for absconding? The simple answer is no. My answer to labor-related questions, in most instances where the question relates to whether you can fire or terminate the employment of an employee who is, misbehaving or absconding or is absent, my simple answer is that you can never ever fire an employee without following a procedure. That is the simple answer. We look into different merits with their specific requirements, but you can never ever terminate the employment of an employee without following a proper process and following a procedure and allowing them an opportunity basically to state their case. So what happens? Your employee has gone AWOL, you cannot find them, you cannot reach them, you've tried to contact them to figure out whether they're returning back to work or not, and all your efforts in trying to reach them have not yielded any success. You cannot fire an employee who you are assuming is absconding without following a process. So the onus becomes on the employer. The onus becomes on the employer to determine whether that employee has an intention of returning back to work. And what I mean when I say the onus is on the employer, I mean it's your responsibility as an employer to determine whether the intention of the employee is to return to work or not. How do you do this if you are trying to call the person and your efforts are not yielding any success? One registered mail or one email is not going to suffice as an attempt to try and get your employee who has been absent without authorization for an extended period of time, right? You need to first try and reach the employee, maybe find out from friends or family members of your employee as to where is the employee, did something happen to the employee, and why have they not returned to work, or why are you unable to reach them, So you have to make a reasonable effort to try and reach the employee. 1 or 2 mails or 1 or 2 emails, send a registered post. In the olden days, they used to refer to a telegram, sending a telegram to the employee to put the onus, to shift the duty, basically, to put the onus on the employee for them to communicate their intention, whether the intention is to return back to work or not. So you send a letter, and in the letter you state that I hereby give you notice that you are absent without authorization from your employment. Please confirm by said date whether you have any intention of returning back to your employment. There, in that way, you shift the onus to the employee for them to have the responsibility to communicate whether they are returning or not back to the employment. You then follow, if after you have sent that letter, the employee does not return, does not respond, give it a day or 2 or 3, I would say, safest bet. If they still don't return, you send a follow-up and you say that we have sent you written communication on said date, and we have called on you to confirm whether you have any intention to return back to your employment. You have since not done so. Should we take it that you have no intention to return back to work, please note that should you not respond by whichever date, this could lead to disciplinary action being taken against you. Okay. Now, that still puts the onus on the employee to come back and say, I do have an intention to return, or I don't have any intention to return, thereby resigning. And if the employee still does not respond to your requests, basically, to your mails, to your letters, you still need to notify the employee once you start the disciplinary process. So then the employee does not return, and now you're at a point where you need to follow disciplinary processes, thereby instituting a disciplinary hearing. You still need to give the employee notice of the disciplinary hearing and make the employee aware of the fact that should they not come to the hearing may proceed in their absentia. And whichever decision the chairperson makes in the hearing is the decision, right? And you are, should you follow that proper process, the chairperson could find the employee guilty of absconding and may recommend for a dismissal. Of course, before you recommend for a dismissal, the codes of good practice, or labor relations codes of good practice, always state that in Schedule 8 that dismissal should always be the option of last resort. So you take all the factors into account: the severity of the absence, the nature of the role that employee fills in your employment, the severity of the circumstances that their absence causes to your business or to your employment, all of those factors, the length of service, whether they have a clean disciplinary record or not, all of those factors need to be taken into account before recommending for a dismissal and following through with a dismissal. Now, let's say that you have followed all of those steps, you have sent all the letters, and your employee still has not returned to work, has not said anything, has been completely quiet, and then you follow through with a disciplinary hearing where a independent chairperson recommends that you dismiss the employee. Now you have dismissed the employee, you still need to give the employee notice of their dismissal, like send them a letter and inform them that on said date we held a disciplinary hearing as per the notice that was sent to you on whichever date, and the chairperson's recommendation was for you to be dismissed. The final decision has been taken in terms of the disciplinary hearing that was held. You are hereby notified of your dismissal. Your summary dismissal, I mean, they're not there, right? And remember, you cannot hold back any money that is due to the employee, any money that they have worked for and is due to the employee. You are not allowed to hold back on all of that money. So if you are owing that employee any money for any services rendered during that month or during that period, you are by law required to pay the employee that money. Now you have dismissed the employee and 2 days later, the person shows up. What then? I mean, it's very tricky because you've already taken a decision to terminate that employee's employment, and say for instance in some situations you've already replaced that employee. Let's take the case of a domestic worker. Your domestic worker, you gave them leave for the festive season. The domestic worker does not return. You give them leave, you say, okay, you take leave from, say for example, the 15th of December until the 4th of January. You are on your December break. This is your leave. We will see you on the 4th of January. 4th of January comes, the employee is not there. You send a messages, they blue tick you. Let's put it like that. They blue tick you. That's if the message gets delivered. You try to call, you can't reach them. You call the family members, no one is giving you any answer as to where they are, right? It is very it's very advisable to maintain proper records in terms of knowing your employee's address. How do you track your employee down? Should you require to find them? Should you require to send a mail? Should you require to have someone deliver a letter for you? You need to have record of the most updated address as to where your employee stays. That's, in my opinion, something that's very, very important. So your domestic worker did not show up for work on the 4th of January like they're supposed to. You've tried to reach them and you have not succeeded. Now, on the 6th of January, you decide, let me send someone to go and deliver this letter to my employee, right, at the last known address that they've provided. That person goes and delivers the letter. You give the letter to your employee's son, your domestic worker's son, who was there at the place of residence, and they signed for it and they received it. Now you have proof that you have delivered the letter, right, to the last known address of your employee. And you have proof of delivery because the son signed and received. Let's take it that the child that we're talking about is a major, not a minor. Right? They've signed for the letter for the employee, they have received it, and they've confirmed who they are, right? Right. You sent a letter, and in the letter you stated that you were supposed to return to work on the 4th of January. You did not return. We have tried to contact you with no success. This is what we hereby call on you to communicate your intention to whether you want to return back to work or not, right? And they don't respond. They receive the letter, they don't respond. That was the 6th of January when you sent that letter. The 9th of January, you decide, okay, I've not heard anything again since the letter that we delivered, and I want to follow up on that letter. And you send another letter to the person. You send maybe via registered post, and you get a delivery receipt, or you send someone to go and deliver the letter that says, we sent you a letter on the 6th of January communicating with you as to your extended absence from your employment without authorization. I called on you to respond and communicate your intention to return back to work, and you did not respond. Kindly note that if you don't respond to this letter by the 11th of January, now let's take it as the next working day. By the 11th of January, you don't respond to this letter, please note that we will follow our disciplinary process and institute a disciplinary hearing to address or investigate your continued unauthorized absence and or absconding from work. Okay, you send that. The 11th of January comes and it passes. On the 12th of January, you send them a letter, or you deliver them a notice via the person that's been delivering however way you've been delivering the notices and the letters. You deliver a notice that says you have been absent from work without any authorization to do so. Please note that on the 15th of January, you are hereby called on to attend a disciplinary hearing to deal with the following charges: unauthorized absence from work and or absconding, misconduct. It's a misconduct, right? Absence from work, and you give the date and time of the hearing, the place where the hearing will be taking place. You explain their rights in terms of the hearing, in that they are allowed to be represented at a hearing, they're allowed to have an interpreter, they're allowed to bring evidence to the hearing, they're allowed to cross-examine any witnesses that the employer will be bringing against them, and also inform them of the fact that the disciplinary hearing can proceed in their absentia should they not show up for work. That is a very important thing, because remember, you're dealing with the charge of absconding, and in all likelihood, if that person has no intention of returning back to work, that person is not going to attend the hearing anyway, right? So you need to inform them that this hearing can proceed in your absence, and should the evidence be found that on a balance of probabilities you are guilty of the offense with which you are charged, the chairperson may recommend for your dismissal. You send that notice, the day for the disciplinary hearing comes, the hearing is held, and the chairperson finds that the employee is guilty, recommends for a dismissal, and you do indeed follow through with the dismissal. You send the employee the notice of their dismissal. 2 days later, once you have found a new domestic worker, bling, your employee shows up. What then? What do you do then? Must you then terminate the new domestic worker that you now hired in replacement of the old one, or do the dismissal stands as it is? You can never ever fire someone without proper process, and what I just described is you going through a proper process, ensuring that you have given your employee an ample opportunity to show you or tell you or communicate to you their intention, whether it is to return or not to return to their employment, and they just chose not to. You've followed a proper process in that you've held a disciplinary hearing, giving them and affording them an opportunity to state their case, and they chose not to show up. It's tricky because you still have to allow the employee an opportunity to be heard once they return, because you could be dealing with an issue where the employee was sick, you could be dealing with the issue where the employee had circumstances that were beyond their control, that didn't allow them to communicate or to return back to work. And that's not to say that you are now compelled to reinstate the employee. You need to give the opportunity for the employee to be heard. you need to hear what is their side of the story and consider it. Take it into account and consider it. And based on the circumstances of the nature of the job that they would be having, the circumstances, the severity of the consequence that their absence could have on your operational requirements. Even in your home, you have operational requirements. And for the fact that you have now gone and had to incur potential costs to replace the employee, all of those factors get taken into account, and you are not obliged to reinstate that employee, but you have to allow them the opportunity to be heard. Take in the information that they are giving you, the circumstances that led to them then terminate or absconding, and you then subsequently terminating their employment, and weigh it on a balance of probabilities of what next. Now, employees who are terminated for absconding still have the right to take the matter to the CCMA. The CCMA will have the obligation to then adjudicate between the parties and weigh up the circumstances whether the dismissal was substantially and procedurally fair. Substantive fairness is the reason behind the dismissal. Procedural fairness is the procedure followed leading up to the dismissal. Okay, so 'tis the season for all weird and wonderful things that are going to be happening between employers and employees, and employees who find new jobs and don't want to serve notice, employees who just want to leave their toxic employments, employees who decide, I'm just not going to return because why must I, right? And as employers, employers have a duty bound by the Labor Relations Act to always follow a proper process in allowing employees the right to be heard. I hope that this has been informative. I hope that you walk away knowing how to be a responsible employee and a responsible employer, and that you will exercise your labor rights with care. My name is Tseho Khailai, and I will catch you on my next episode of my Lawyer's Corner.